If a doctor has been sued multiple times before, can I use that to cross-examine him at the time of trial? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. Today I'm on vacation in Florida with my family and I have a few moments to share this great information with you. So now, if a doctor has been sued multiple times, can I use that to cross-examine him at the time of trial? The answer is yes, but no. Let me tell you what I mean. The mere fact that a doctor has been sued does not automatically mean that there was carelessness and that he caused someone harm. In order for me to really use that information, the doctor had to have gone to trial and a jury had to have decided that the doctor was legally responsible and now was obligated to compensate to the injured patient a certain amount of money. In that instance, I can now use that particular case, that particular verdict, and the testimony he gave in that case to cross-examine him in your particular case. Now, the mere fact that someone has sued does not automatically mean that they're responsible. So, if the doctor's been sued 10 different times, can I use that to show to the jury in your case the fact that this doctor was careless, the fact that this doctor did something wrong and caused you harm? The answer is no, I can't. Why is that? Well, let me give you a great example. Let's say you're driving down the highway and you were speeding and you get pulled over by a police officer. Let's say the police officer checks your history and it turns out you got 5 speeding tickets in the last 5 years. The mere fact that you had 5 speeding tickets in the past, does that mean that you were speeding in this particular instance? The answer obviously is no, it doesn't. The same thing applies in a lawsuit when you're suing a doctor and now it turns out the doctor has been sued and may have active cases going on. Those pending cases do not automatically mean that the doctor is culpable and responsible for what occurred to you in this particular case. There are instances where we can obtain testimony that he has given in a pending case or in a prior case to then use against him if it contradicts something that he has testified about in your particular matter. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in a medical malpractice case in the state of New York. You know, I recognize you're watching this because you likely have questions or concerns about your own particular matter. Well, if your matter did happen in New York and you've got legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.